Greetings and salutations, all of my fellow American sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class. And tonight we are going to be doing a workshop for the VSOF about editing documents. Specifically, we're going to be editing notices of understanding and intent that will go along with the process service of the Vocational Science of Freedom status doc set. Now, these are more or less optional, but I've had several people come to me and say, well, is there anything else that we give to the process server aside from the VSOF status doc set when they go to serve it on, say, the county sheriff or the governor or whoever you might be serving? And I said I could create something, and then there was a collaboration, but there's been some updates and some edits. So anyway, what I'm going to do is this is going to be a workshop where you guys will watch what I'm doing in real time to edit these documents. So from the start, this will just be number one, and I'm not going to get fancy with it. I'm just going to call them Vocational Science of Freedom workshops. So this is how to properly create and edit lawful documents. And tonight, specifically, process service on government agents regarding the VSOF status correction documents. So what is due process, and why do you need to process serve the government with anything? So first, let's understand what process is. Now, these various definitions are all going to be coming from Bouvier's Law Dictionary. So process. Now, this is the definition of what you would think of as the totality of court process, even though it does deal with notices as well, okay? So process, practice. So denominated because it proceeds or issues forth from a court in order to bring the defendant into court, or it issues forth from you to give notice to someone so that they stop doing whatever it is they're doing to you, so you don't have to take them to court, okay? And then to answer the charge preferred against him, and signifies the writ or judicial means, which is an aspect of a notice from your house, that is a judicial means, by which he is brought to answer, meaning to answer whatever it is that you're questioning or you're putting them on notice of, to say, hey, please stop stepping on my foot. So second definition, again, process, practice from Bouvier's. In the English law, process in civil causes is called original process. Now, when you talk about civil causes, do not confuse this with Roman civil law. I had to explain this to somebody the other day, and it literally took me like an hour and a half to get their heads wrapped around this difference, because this term civil is used in different ways in law. So how they're referring to it here, when you're talking about civil causes are in contradistinction to criminal causes or a criminal charge. So when you have these processes in courts, you're going to say, oh, is it civil or is it criminal, right? And civil causes are the things like you suing corporations, corporations suing other corporations, corporations suing you suing the state, so on and so forth. But usually when the state, or technically the people of the state of, say, California, are bringing a criminal process against you, that's a criminal cause instead of a civil cause. So I just don't want people to get confused about the word civil, because then the difference between common law and Roman civil law are two different systems of law. But when you're talking about doing things in court, it means something different. So anyway, I just wanted to make sure that everybody knew that so you don't get confused. Okay, so I'll restart. All right. In the English law, process in civil causes is called original process when it is founded upon the original writ. Now, that means common law process. The way that American jurisprudence has, well, I'll just say what it is, has been corrupted, is that the attorney doesn't want anybody doing anything at law anymore. So under equity procedure federal rules of civil procedure, state rules of civil procedure, you're never going to see in those rules that you need to create an original writ. And I don't want to get into the whole process of common law procedure. That's something that we covered in the totality of law and the ins and outs of court. So I don't want to rehash that. But I'm just saying that original writs are something of common law, not equity or maritime admiralty or ecclesiastical. Okay. All right. So continue here. And also to distinguish it from mens or mens, that means middle, or intermediate process, which issues pending the suit. So those are things like your back and forth of your service of your original writ and the answer to the writ and so on and so forth. Again, that deals with common law procedure. Okay. Upon some collateral interlocutory matter as to summoning juries, witnesses, and the like. Mens process is also sometimes put into contradistinction to final process or process of execution, meaning whatever the final judgment of the court is, and then what's usually called, or what used to be called, the writ of execution. Now they're called, they're usually called like writs of assistance, at least if you're going to have the sheriff go and take something back from someone. And then it signifies all process which intervenes between the beginning and end of the suit. So that is where things like simple notices, which we'll be going over tonight, have to deal with. And then third definition of process practice. In criminal cases, the proceeding which is called a warrant before the finding of the bill is termed process when issued after the indictment has been found by the jury. So let me break that one down. So in criminal cases, so again, we're talking about criminal, not civil, that proceeding which is called a warrant. So when the court has a proper evidentiary hearing, creates a warrant of commitment, that's part and parcel of process, criminal process. And then before the finding of the bill. So what's a finding of a bill? What's a bill and how are they finding it, or who's finding it? Okay, so a true bill is something that is created by a grand jury, specifically 25 members of the peerage creating a grand jury. So the grand jury finds that someone should be indicted. They then create a true bill, and then they give that to usually the prosecuting attorney to go and then have a court case about whatever the guy did. Theft, murder, whatever. Okay. All right. And then is termed process when issued after the indictment has been found by the jury. So that means all that stuff that happens after it. So we have probable cause, we have witnesses, at least two witnesses who saw somebody do something. They bring this testimony to the grand jury. The grand jury says, aha, there should be a warrant of commitment created, and give that evidence to the court. The court's job is to create the warrant of commitment, not the grand jury's job. The grand jury's job is to create the true bill of indictment, and then on and on it goes. Okay, so that's process. All right, so what's service? Service practice. Again, this is from Bouvier's. 1, to execute a writ or process. As to serve a writ of capias signifies to arrest a defendant under the process. To serve a summons is to deliver a copy of it at the house of the party, or to deliver it to him personally, or to read it to him. Now, nobody ever reads process service to anyone anymore because they usually try and walk away from you. But anyway, there was a time, going all the way back to ancient Rome, where service of process literally was somebody standing in front of your house and yelling at you. There wasn't even paperwork. So anyway, to continue. Notices and other papers are served by delivering the same at the house of the party or to him in person. That's what we're going to be talking about tonight. So the notices. So how do you do service of process? You let somebody else who's over the age of 18 take whatever it is that you wish to be served. They take it to them. They find their place of abode, and they then serve those people whatever it is that you want them to have, whether it be a lawsuit, whether it be a notice, whether it be a writ, original writ, right? Or even paperwork that might have something to do with, say, discovery, matters in a court of equity. Okay. All of those things are things that can be served. And to do so, again, it just has to be somebody over the age of 18. They walk up to the place or they find the location. And if it happens to be a business, meaning there's no other place that whoever might be able to be found, or say they live in some gated community and there's no way you're ever getting in there to find them, but you can say find their work. Well, then the process server would go to the work and say, is John Doe here? And if they're dealing with, say, a security guard, the security guard may say, yeah, sure, John Doe's here, but you can't see him. The process server then, right then and there, would drop the papers or whatever it is at the guard's feet. And, well, first, actually, let me back up. First, they would say to the guard, what is your name? My name is whoever, John Smith. Okay, great. Thank you, John Smith. John Doe is now being served this. And then you drop it at the guard's feet and you walk away. Now, how or why can you do that? It's because if somebody is saying to you up front, whether it be a clerk, whether it be somebody at a front desk, whether it be a security guard, I don't care. If somebody's basically operating as being in control of the office or the location at the time, then they are the ones that can have the documents given to them, because apparently they were in charge of the office at the time. And that is how a process server should write that down in a process service affidavit. Said, I went there on Tuesday. I served John Doe by dropping the documents at the feet of John Smith, who apparently at the time was in control of the office, right? Or something to that extent. You basically explain it in the process service affidavit that this was the guy in charge because he didn't let me pass, so I gave it to him. And then it's his duty to give it on to the people that basically he's hiding or protecting. But it does not, under any circumstances, get the party of which you're trying to serve off the hook. Sorry, that doesn't work. So anyway, that's just a little lesson in process service for anybody out there that wants to do it for someone else. Another aspect with process service, you cannot do it yourself. Do not ever attempt to serve documents for yourself. You cannot do that. You cannot serve your own documents, nor can you write out a process service for yourself. It always has to be a disinterested third party, as long as they're over the age of 18. And if you guys want more information about process service, most states always have it listed in their rules of civil procedure for the most part. Now, you're going to find some states that might not have it. Sure. The other places you can go looking are manuals for notaries. They usually also have at least a few paragraphs, if not a few pages, on process service, or at least the ones in the old days used to. There might even be process service, say, small books on the procedure, perhaps. It's not that big of a thing to understand, or there isn't that much that really entails in the process itself. So, but I'm not saying that somebody might not have written a small book about it. They probably did. And then there's probably sheriff's manuals also that probably talk about it, because the sheriffs are usually the ones that go out and serve whatever it is that needs to be served, either for courts, the district attorney, and you can hire a sheriff as well. You just take the documents, pay them whatever amount of money they want, and you give them the certified copies of whatever it is you want to serve. You could probably pre-write out a process service affidavit to make sure that all of the documents that are to be served are specifically listed, so the sheriff doesn't mess that up, because some of them are lazy from time to time. And then give it to them, and then that's their job. And then they'll sign the fact that they did serve on such and such date, and then they'll bring it back to you. Some of them will, again, not play by the rules exactly, and they'll be like, well, we couldn't find them or we couldn't serve them. If it's somebody that the sheriff might say, I don't know, be in cahoots with. But anyway, if you want to make sure that that never happens, train your own process service agent. That's really the best thing to do. So, yes, Harley, you can. Bailiff can serve certain things in certain matters, but usually you do not ever process serve anyone. But I'll put it this way. You can never process serve anyone in court, meaning while court is open and in session. So don't ever do that, because you can literally be held in contempt of court for it, because that's something that's never supposed to happen within the confines of court operating or being open at the time. Now, if court's not open or at the time, and say everybody's just walking into court, but court hasn't started yet, your process server can definitely serve somebody that walks into court that they know that's who it is. They can definitely get served, because you can be served anywhere. Doesn't matter. But just don't make absolutely sure that you're not doing it whilst court is actually in session. And so would bailiffs ever actually do that? Probably not, because the bailiff's never really there until court is actually open and in session. So unless you're referring to, say, the more ancient definition of the term bailiff, but that we don't really have them anymore, so I won't get into that. Okay, so back to definition of service here. All right, second definition. When the service of a writ is prevented by the act of the party on whom it is to be served, it will, in general, be sufficient if the officer do everything in his power to serve it, which is exactly what I said regarding Mr. Security Guard. Okay. Did the process server do everything in his power to serve it? Yep, sure did. Okay, so what does this say? When service of a writ, and it doesn't just mean a writ, but anything else, a notice or whatever, is prevented by the act of a party, meaning some security guard or some uppity clerk, whoever, on whom it is to be served, it will, in general, be sufficient if the officer do everything in his power to serve it. That's it. You cannot get off the hook just because you want to dodge service. Sorry, doesn't work that way. Okay, so that was service. Now let's get on to what a notice is. Notice: the information given of some act done, or the interpolation by which some act is required to be done, or not done. It also signifies simply knowledge, as A had notice not to administer B's estate, which is exactly what the vocational science freedom status docs say to these people. 2. Notices should always be in writing. They should state, in precise terms, their object and be signed by the proper person or his authorized agent, be dated, and addressed to the person to be affected by them. And that must have been a little typo in the process of transferring over from Bouvier's Law Dictionary. There's no reason for there to be a hyphen there, so just take note of that. All right, number 3. Notices are actual when they are directly given to the party to be affected by them. So when a process server hands whatever to whoever, they have now gotten actual notice, which you can state in your process service affidavit. You can say John Doe had actual notice of these 7 documents on such and such date, served by whoever, right? And it says then semicolon, or constructive, as when the party by any circumstance whatever is put upon inquiry which amounts in judgment of law to notice. Okay, now what the hell are they talking about there? That's an aspect of things like putting notices into state journals, because there are ways to do notices. And you can even do this, you can technically even do service this way, even though it's very frowned upon as far as courts are concerned, because you really do want to actually find the person. But anyway, so you can put notices into the state journals, and every single state has some statute written that states what the state journal is for state notices, for publication of state notices. So if you needed to say, I don't know, put a company or some business on notice, and you could never find an agent, or they're never there, or they always, I don't know, lock the doors as soon as you start walking up, whatever, then you can put that into the newspaper. And then what the newspaper will give you is an affidavit of publication. So when it says here, as when a party by any circumstance whatever is put upon inquiry, which amounts in judgment of law to notice, getting that affidavit of publication from the state journal is exactly that. Okay. And then provided the inquiry becomes a duty, meaning you told him, hey, stop stepping on my foot, or, come get your horse off my lawn, whatever. That's a duty. Because if they do not do, or if they do not stop doing what you tell them to do, and a harm may be incurred, then they have a duty to stop doing it, whatever that may be. And that instantaneously becomes a duty once they've been noticed of it. Now, attorneys don't like that, but who cares what attorneys think? This is all about lawful due process, okay? That's where the whole aspect of the term that you have the right to due process comes from in all of the constitutions. This is what we're talking about. Okay. So now that you know what I will be working on tonight, let's get to work on editing some notices. What I will be editing tonight is VSOF member created, meaning they pretty much created these documents on their own. There was some back and forth between me and a few other VSOF lifetime members about how these things came about. And then we exchanged them with each other a few times, and they went through a few edits, but I still have to do some final editing, which is what I'll be doing tonight. Okay. So these notices should be added as a cover document when someone process serves a government agent or agency with the VSOF status correction documents. Okay. All right. So let's get this going. So the first one I'll bring up is an affidavit of service. So this is what an affidavit of service looks like. And let me blow this up a little bit so everybody can see it, hopefully. And it's very simple. There's not much to it. For the most part, I try and keep everything in red if it's something that needs to be altered or changed within the document. So David Lee, House of Roberts, there should probably be a hyphen there. P.O. Box, whatever, Illinois, so on and so forth. I always put the zip codes in brackets. There is a odd rule, which is called the four-corner rule of construction of legal documents, that states that basically if something is in a box, literally a box on the document, technically it's not on the paper. As batshit crazy as that sounds, trust me, I've looked it up and verified it. I didn't believe it, had to go check, but anyway. So then putting brackets around something also does the same thing. So why do I put brackets around a zip code? Because I don't want to be stuck under the Buck Act from an aspect of somehow I'm in federal jurisdiction or federal territory, and therefore not in one of the several states of the American Union. And yes, I know that's a lot of rambling over just about a zip code, but that's why it's there. Okay, state of Illinois, in the Circuit Court of 17th Judicial District, Winnebago County. This would be your title, your start title, if you already had something going in court, like you already served them, or in this case, it happened to be for habeas corpus. So you do this whole part set up as you would do with any court case, basically your heading of any court case, if indeed you have something already going in court. If not, you would pretty much just get rid of this, and it would just say process service affidavit down here, and you wouldn't even bother with the court heading. Okay, so David Lee, House of Roberts, case number, whatever, plaintiff versus so on and so forth, defendant, that should be defendant. Okay, and process service affidavit. This is where you put whatever it is that you're doing. So when the court clerk looks at this, they say, oh, that's what this is. Pretty much every single time what you put here will usually end up as the name of whatever it is in the actual docket, meaning however the clerk decides to enter it into the court record. It's usually by this that you put here. And then in re means in regards, habeas corpus for David Lee, House of Roberts, attested, signed, sealed, process service affidavit. So Stephen Derek D. Bioki comes now and states that I am not a party to the writ of habeas corpus for David Lee, House of Roberts, that I am over 18 years of age. That's important to put down. That I'm one of the people of Illinois. That just establishes that the process server is sovereign, literally. And that I have served one file stamped certified endorsed copy of writ of habeas corpus in re David Lee, House of Roberts, one copy of petition for writ of habeas corpus by a people in state constructive custody, not sentenced to death, notice of default, and one copy of attachment A of said petition, law of the case to Sergeant T. Roberts on September 2nd, 2018. Okay, so all of this part from here to here would be where you would lay out what it is that they served. So within the here to here would be, if you were doing it for the vocational science freedom status doc set, it would be the entire list of all of the documents, properly spelled out and listed with commas in between. Okay. 2, and this was whoever was actually taking the document. And then who at the time of the aforementioned documents was a deputy sheriff of Winnebago County, Illinois, an employee of Winnebago. Wait, hold on. Sergeant Roberts versus. Oh, no. Okay. So this is the guy that was basically, so this is the guy that would be quote unquote in charge of the office, right? Okay. Deputy sheriff of Winnebago County, Illinois, employee of Winnebago County, and okay. This is where the important part, and apparently in charge of the office of Winnebago County Sheriff. So you go to serve the sheriff, some deputy gets in your way. They say, you can't see the sheriff. Great. Don't care. Drop it at his feet, walk out. Okay. And of the aforementioned service documents are on file with the clerk of the court, case number, so on and so forth. And then you can put footers in here if you want to. So anyway. Oh, and by the way, this is the regular service of process. So actually, I need to fix this footer because this is not the amended process service affidavit. This is just a process service affidavit. Okay, fixed. So then you put down your date served, the time, the sex of whoever it was. That technically should be a man, I think, if it was Mr. Sergeant T. Roberts. Oh, I guess suppose it could have been a woman. Whatever. All right. So anyway, this is, again, all of this is in red. So everything that's in red gets changed to whatever the case may be with you, right? So plaintiff claimant, David Lee House of Roberts, defendant, Gary Kawanio. And then just realized that shouldn't have been there either because somehow or another that got moved from the top. So we don't want to say that. We want to say having to do with Roberts being the defendant. So this guy, the sheriff, is actually the defendant. Okay, fixed. Teste. Teste means, teste literally is the root word of testicle. And to make a funny joke, and well, it's not a joke, it's actually historically correct. When people used to give testimony, only men could give testimony because they had to hang on to what they would lose if they were caught lying. Yes, not a joke. So when you gave testimony before judges or inquisitors or whatnot in the ancient world, and you were a man, they literally made you hang on to your balls. And if you were caught lying, you lost them. That's why the word teste means what it means, and that's where we get the word testicle. That's also where we get the word testimony. So teste is just simply stating what that is. I am Stephen Derek D. Bioki, one of the people of Illinois. I have personal knowledge of the above stated facts and am competent to testify as to the truth of these facts if called as a witness. I am the above stated process server. I declare under penalty of perjury, under the laws of the United States of America. That little part is very specific. Under the laws of the United States of America, that means not the United States, literally. So you are separating yourself from the United States by doing that and stating that within wherever you're stating it. Just here is on the test day. But anyway, there's literally a U.S. code that lays this out, that if you state it exactly this way, that you are not under the United States. All right. And that the foregoing statements are true and correct. All right, fine. All right. Served by, and then he would sign here, signed and declared before me, this, whatever. And then if you go and get it notarized. So pretty much all process service affidavits are always notarized. So they go and do this. They then take this document, fill it out, or you fill it out for them. And as to everything that's supposed to be fixed regarding your case or your situation. And then the process server goes before Notary Public. Notary Public signs it, puts their little seal here. And then you take this whole thing and make a copy of it. And then you go file one of them into the court record. You then have a proper process service affidavit upon the court record. So that's process service affidavit. And then the only one that I'm going to show here, or the only thing that's different about this one specifically, is that this one is the amended process service affidavit. So it looks pretty much exactly the same. The only thing that's different is that if you were to ever need to change anything, you can literally say in here that this process service affidavit amends in its entirety. Should get rid of the apostrophe. In its entirety, the process service affidavit filed into the court or wherever it should be. So I actually should make that red into the court record, because sometimes you want to file process service affidavits onto the public record. That's perfectly fine. You can do that too. On such and such time, case number such and such, and for it did not include a complete list of the documents served. Okay, so you can amend things whenever you need to, right? So that's the same document, but the only thing that's changed is that it's an amended process service affidavit. Okay, and then next thing we'll take a look at will be the template for a notice and demand. So this will be basically a generic look at what a notice and demand and the elements thereof should be in it. So, and by the way, if anybody notices this as being somewhat familiar, I got this from Bill Thornton. So, notice and demand elements. There is no penalty for making reasonable mistakes in good faith. But if one intentionally does harm, then he may be sued. But before he can be sued, he must be given a fair opportunity to correct his error. The notice gives one fair opportunity, or that fair opportunity. By it, he may have sufficient notice to assert proper diligence and inquire further as to discover that which an inquiry pursued in good faith would disclose. Meaning, if you give somebody a notice, you have to tell them, hey, buddy, this is what's going on. Now, if they don't assert proper diligence, meaning they don't take the time to figure out what the hell it is you're trying to tell them, and inquire further as to that which would discover which an inquiry pursued in good faith would disclose, meaning, okay, how did this happen? Did my tree accidentally fall over onto your barn last night because there was a windstorm? Or does it look like somebody came and cut the tree, right? You have a duty to inquire as to how you're doing harm or potential harm to someone else. If you don't do that, you are automatically in dishonor in the eyes of the court and automatically in dishonor in the eyes of pretty much the entire society. All right, to continue. There is a wide latitude in the style to use to write the notice. You can pretend you are writing to your sweet old grandmother or to the devil himself. From the court's point of view, the style doesn't matter if the legal points are made. Choice of style is a strategy decision. What effect you do want to have on the offender. Do you want to piss him off? Do you want to scare him? Do you want to be sounding very meek? Like, oh, can you maybe please stop doing this? To see if he'll do something stupid, like not reply, right? Those are all strategy decisions, okay? So before sending the notice, remember to apply Mark Twain's 7 rules for good writing. Revision, 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 revision. It takes 7 major revisions to do a notice correctly. Good point. In your notice of your adversary, make the following points. What he or she is doing. 2, your injuries, e.g. loss of substantive rights. Notice injury and damages are not synonymous words. Injury is the harm done. Damages are the compensation you want for the harm done. And 3, his duty to not cause injury. The moral, public, and private laws that require him to not cause you injury. So you can list things like the 10 Commandments, Bills of Rights, U.S. Code, or those specific U.S. codes, because 18 U.S.C. subsection 242, that's deprivation of rights under color of law, and some other ones in there, whatnot. And your own rules, just simply saying, hey, nobody in their right mind would continue to, drive across my lawn in your, souped up Jeep and put ruts in it, whatever the hell it may be, right? 4, that he is breaching that duty. So you kept doing it. I told you not to do it. And if you keep doing it, then you're breaching the duty that you owe me because I've now given you notice to not do it. Okay. 5, state the damages, what he owes you for the injury. Cite the moral, public, and private measures of the damages. Again, biblical, USC sections, whatever, and your own estimate. 6, demand that he, in good faith, do his duty, pay you the damages, and to do so within a reasonable number of days. Usually 60 days for government, or actually, I think you should always give 90 days for government, 30 days for everyone else. 7, if he does not do as demanded within the allotted time, then by tacit procuration, which means assumed power of attorney, you will determine for him the facts, the duties, and the damages he owes you. Now, within the Vocational Science of Freedom Status doc set, once you give them the offer of contract and appoint them as trustee of your estate, and they continue to administer your estate, and then they do not do what they're supposed to do based upon that contract, you can take power of attorney over them. And yes, there are people that have done that. You can take a power of attorney over a judge or a district attorney or even an attorney general. I know of a man one time that took a power of attorney over Eric Holder and then signed Eric Holder's name. And by the way, Eric Holder was the attorney general under Obama. Signed Eric Holder's name to a document, and Congress actually had to obey it. Long story, I won't get into it, but I've stated it before. It was the aspect of the case of the private bill that Stark did for billions of dollars to Congress. But anyway, I digress. Number 8, if he does not perform as demanded, you will take lawful action in personam and in rem. So in personam means against the person, and in rem means the thing or against a thing. To defend against him and persons acting in concert with him who cause or attempt to cause said injuries. To secure your substantive rights and to redeem the damages owed to you. Okay, fine. I don't know why this is in red. I didn't need to have it in red. It's actually a little annoying to read. Okay, fixed. And okay, so the constructive notice should be served upon the adversary in the same manner that one would serve a summons in a lawsuit. Which is exactly what we stated before. So how I was describing how process service happens, right? All right, so proof of service should be executed and held for use as necessary in a future lawsuit. Again, we already just looked at that and how to do it. Knowledge of facts which would naturally lead an honest and prudent person to make inquiry constitutes notice of everything which such inquiry pursued in good faith would disclose. So I gave you a chance to stop stepping. In another sense, notice means information, an advice or written warning in more or less formal shape, which is what we'll get into, intended to appraise a person of some proceeding in which his interests are involved, or informing him of some fact which it is his right to know and the duty of the notifying party to communicate. Hey, maybe you didn't know that your cow was deciding to eat my flowers. Probably didn't, or else you probably would have came and got your cow. So I'm telling you, keep your cow off my lawn, right? So, and then actual notice has been defined as notice expressly and actually given and brought home to the party directly. That's very tantamount to the definition that we read earlier. The term actual notice, however, is generally given wider meaning as embracing two classes, express and implied, which we also talked about. The former includes all knowledge of a degree above which depends upon collateral inference, or which imposes upon the party a further duty of inquiry. Again, get your cow off the lawn. The latter imputes knowledge to this party because he is known to be conscious of having the means of knowledge. Okay, so that would be something like, hey, I put a no trespass sign all the way around my property, and all of a sudden I find you picking morels in the back of my woods, right? So that's notice that he already had. So consciousness of having the means of knowledge, like the signs were there, buddy. You already knew it. So in this sense, actual notice is such notice as is positively proved or have been given to a party directly and personally. Again, you can just take literally a picture of your no trespass signs and say, look, they've been up. Or such as he is presumed to have received personally because the evidence within his knowledge was sufficient to put him on inquiry. Okay. Or such as he is presumed to have received personally because the evidence within his knowledge was sufficient to put him upon inquiry. Oh, okay. So like a document that you served him, proving something, maybe like a deed or something of that nature. All right. Constructive notice is information of knowledge of a fact imputed by law to a person, although he may not actually have it, because he could have discovered the fact by proper diligence and his situation was such as to cast upon him the duty of inquiring into whatever. So let me think of an example of that. Something that somebody should have had knowledge of had they bothered to go look would be, well, in a sense, notice of the law. Well, I don't want to go there because the attorney corrupts that one all the time. I don't know, just anything else they should be aware of. Okay, I'll give you an example. Like, say there's a not open sign or a closed sign on some place of business. It simply says closed. The lights are not on, right? That's notice that says there is no public access at this time to this location. Because if you put up a open for business sign, that then tells everybody that there is public access to this location to come do business here. So that would be something of that ilk. Okay. And then constructive notice is a presumption of law, making it impossible for one to deny the matter concerning which notice was given. So constructive notice then would be something like literally a judgment from a court, or say the findings of a hearing of, binding arbitration would be one. So if you had a binding arbitration proceeding and the arbitrator wrote out the judgment and so-and-so got served with the judgment, right? That would also be considered constructive notice. Okay. So while implied notice is a presumption of fact relating to what one could learn by reasonable inquiry and arises from actual notice of circumstances and not from constructive notice. Okay, so that would be just like a regular notice. Okay, so let's get into this thing. Instead of reading all those crazy definitions, which are very difficult for a lot of people to follow. I hope I did the best that I could to explain it. All right, so here we go. This is a basic notice and demand. This is literally from Bill Thornton. I just added some things here and there for clarity, but this is a template. Okay, so notice and demand example. 2, you are obligated. Hey, you signed it. Principle 1, Principle 2. Please take notice of the following. Factual background. On February 1st, 2025, I be injured and you are obligated, entered into an agreement, a copy of which is attached as Exhibit A. Always good to add things to your notices. You want to attach things to your notices if it's some sort of thing that is a document. Maybe it's a deed. Maybe it's a picture of your ex-wife kissing somebody, or your current wife kissing somebody. I guess if it was your ex, you wouldn't really care. But anyway, something, whatever, evidence of whatever the hell is going on, right? Picture the tree fell down, totally destroyed the barn, whatever. All right, presented himself. Okay, so this is now getting into some sort of facts. Presented himself as a leasing agent, duly authorized to act in this manner for the owners. You are obligated. Also represented that, hey, you signed it. The signatory to the agreement was one of the owners of the property. Okay, so you're kind of starting to lay out what's going on here. So anyway, that's what this is. And I'm not going to read all of this because, again, this is just a template. So you do your factual background. So this is your who, your what, and your where, and possibly your when, but not your why. Okay, so that's all that. So breach of agreement. So this is what happened in the breach of the agreement, or how, say, the one that you're serving is stepping on your toes. So it might not be a breach of agreement. It might be, you might say breach of duty, or you might say notice of trespass. Well, anyway, you get the point. So what you're saying here is what's going on. Like, why do you have any duty to basically stop doing what you're doing? So the breach of agreement, that's contractual. Injuries, how you've been injured, their duty. So you have a moral, legal, and lawful duty to not cause injury. In accordance with the universal imperatives, you must, which is basically natural law, you must not engage in any activity such as extortion, lying, or breach of contract, which would cause an unwanted injury to another. Those universal imperatives are codified in the codes of the state of California, or whatever republic you live in, i.e. penal code, civil code, business, and professional codes. You could also list if there was anything federal. As I said, that's where you put in U.S. code. If you are a Christian and you want to get biblical, you can throw in Bible passages here. So be it. Again, this is your notice. Write it how you want to. Breach of duty. You are breaching whatever it is you stated here, refusing to do X, Y, Z, right? And then restitution and penance. This you can alter. You can name this different things if you want to. In fact, you can even leave this whole section out if you want to. But restitution and penance is basically, hey, what I need from you is an apology and get your fucking cow out of my flowers, right? That's all I need. If that's what it is, that's fine. No problem. If it's you owe me $2 billion because you blew up a tanker facility, okay, then that's what you have to give me for restitution. Whatever it is, that's what has to go in here, okay? And then demand. This is where you do demand and say, hey, within so much time, you got to do what I told you to do up here. And then default, this is where it can get fun. If you fail to satisfy the demand within the allotted time after having been duly served with this notice and demand, then by tacit procuration, again, we know what that is, I be injured or his nominee or his assigns will determine for you the following. 1, that the aforementioned demand is just. 2, that a court of record in California may enforce the demand either ex parte or con parte. 3, that you and each of you concur and are satisfied with the justness of the demand and the process by which the demand shall be enforced. Meaning, if you want to enforce it in a court of record, tell them that. If you want to enforce it by binding arbitration, tell them that. If you want to enforce it by, I don't know, trial by battle, tell them that. Doesn't really matter. However you want to enforce it, that's up to you. And why can you do this? Because you're sovereign. So, further, if you fail to satisfy the demand within the allotted time after having been duly served with this notice and demand, then I be injured will take lawful action in a court of record, in personam and in rem, or in any of the ways that I just suggested. 1, to defend against you or any of you persons enacting in concert with you who have caused any injuries to I be injured. 2, to secure his substantive rights. And 3, to redeem the aforementioned restitution and penance owed to him, or whatever the hell it was that you said. Make sure that this section right here, this right here, restitution and penance, make sure that this matches up with whatever on earth you said here. Okay, so make sure that your sections and your repeating statements always follow each other. And then lastly, please do not contact I be injured by telephone in order to avoid any misunderstanding. All communications shall henceforth be on the record, i.e. in writing and duly served. Please serve all communications and process service directly to wherever, whoever, End of that. Okay, so that's your template. That's what a template looks like for a notice of understanding and intent. Now let's get into a cover letter for, and this is just a governor, doesn't have to be Iowa. All right, so let's do the governor template. And just going to check and see what other ones. Okay, so we'll probably get through some of those tonight, maybe not all of them. All right, so the template of governor letter. So again, this can be given to and added to the VSOF status docs when you're serving the governor. So to governor, office of the governor, state capital, such and such address, Iowa Republic. Again, zip code in brackets. Attention, Kim Reynolds, or whoever the governor is. Attention, Kim Reynolds, governor of the state of Iowa. Okay, so governor of Iowa is different than the state of Iowa. This is the republic. This is the corporation, which they created after Reconstruction. And this thing is subject to the feds. This thing is not. This thing only gave certain powers, vested powers, to the feds in the federal constitution. This thing doesn't have any. This thing is a legal fiction completely. All right, so give the date to whom these presents may come greetings. I, John Henry, House of Simon, hereinafter claimant or claimants, am now serving upon Governor of Iowa Kim Reynolds, make sure these always match, and the entire office of Governor of the state of Iowa, hereinafter you, your, or yourself, certified copies of publicly recorded documents, so that you and all future successors that shall ever hold any office within the state of Iowa are made aware of and are placed on actual constructive and implied notice of all that is hereby served upon you. Okay. So if you're serving the governor of Iowa, that you and all future successors that shall ever hold any office within the state of Iowa. Okay, you can't do that. So you can't force, well, it's an incorrect statement because basically you're serving the governor, and if you wanted all of the rest of, say, the corporations of Iowa, then you would want to serve the attorney general. But if you serve the governor, they can't be required to then, well, would they be? I don't think they'd be required to give notice to any. So ever hold any office within the state of Iowa. I don't think that's possible. All right, so I'm just going to say that you and all future successors should be ever hold the office of governor within the state of Iowa. Within the state of Iowa. Ever hold the office of governor for the state of Iowa and or the capital are made aware of and are made aware of, which be comma, and are placed on actual constructive, again, comma, and implied notice of all that is hereby served upon you. Right, because it could be an entire stack of the VSOF status doc, so it's not just what's contained herein. All right, so claimant's noble goal. And here's another thing, too. If you wanted to add more of your status as to who you are, then you would do it up here. So you would say, I, John Henry, House of Simon, say one of the people of the state of Iowa, comma, hereinafter claimant. So now by stating this, that you're one of the people of, now you've said that you're sovereign, quietly. So I, John Henry, House of Simon, one of the people of the state of Iowa, hereinafter claimant or claimants. So now when you say claimant down here, you're also saying, you're saying again that you're one of the people of Iowa. All right, so claimants, noble goal. You don't have to do that now, right? So you don't have to keep repeating that same statement over and over. Because then when you say claimant, it is all of the things that were above claimant here, right? So everything that precedes hereinafter claimant or claimants, you put all of that stuff in so that every single time throughout the document, when you say claimant, you don't have to repeat it. Okay? So anyway, all right, claimant's noble goal, who has been found to be living and having come of full age, is to have a full and complete, okay, again. So right here, this part, whack, cut. That needs to be up here, not down there, right? So again, you don't ever have to say it again. So in case it ever comes up, don't do that. Okay, so we get rid of that. All right, start over. Claimant's noble goal is to have full and complete accounting of and have and hold all of claimant's now claimed estate. Yeah, we can do that better. Claimant's noble goal is to have full complete accounting of and have complete livery of claimants, not now claimed estate, because you don't need to state that, claimants entire gross estate as stated in the publicly recorded documents now served upon you, and all property that which rightfully belongs to claimant and claimant's future heirs. That might need to be flipped. All right, claimant's noble goal is to have a complete accounting of and have full complete livery of claimant's entire gross estate as stated in the publicly recorded documents now served upon you. And I should think, all right, and to have the same for all property that which all property, get rid of that, which rightfully belongs to claimant and claimant's future heirs. Okay, now that makes sense. In serving the following publicly recorded documents upon you as respondent superior and many other people, agencies, organizations, corporations, government societies, persons, and entities, de facto or otherwise, is to, okay, hold on. In serving, okay, okay, this needs to be done correctly. All right, done better. All right, so claimants, let's say this, claimants, noble goal in serving the following publicly recorded documents upon you as respondent superior and many other people, agencies, de facto or otherwise, is to make it perfectly clear to all the world that claimant is fully aware of what has happened to claimant's estate, property, lands, and republic, making it absolutely necessary for reasons of life and limb to have claimant's entire estate to the exclusion of all others. That seems too wordy. All right. So de facto or otherwise is to make perfectly clear, is to, all right, you don't need perfectly, is to, all right, is to state to all the world. The claimant is fully, the claimant, so you don't need, to even, it doesn't, that's stated. You see, you don't ever have to state in a notice what you've already stated in the documents that you'll be serving them anyway. So it's to state to all the world that claimant has, say this, claimant has made lawful claim to his estate, property, lands, and republic for the reasons of life and limb, comma, to the exclusion of all others. All right, let's see how this reads. Okay. Claimant's noble goal in serving the following publicly recorded documents upon you as respondent superior and many other people, agencies, organizations, corporations, government societies, persons, and entities, de facto or otherwise, is to state to all the world the claimant has made lawful claim to his estate, his entire gross estate, property and lands, and republic for reasons of life and limb to the exclusion of all others. Okay. That now makes sense. What's up, Flood? Claimant has served these documents upon appointed trustees to correct any error and any position of any of them may have regarding claimant status and to correct any presumptions that would alter the same. Okay, that sounds a little bit twisted. Claimant has served these Claimant has served these documents upon appointed trustees to correct any error and any position any of them may have regarding claimant status. All right, so first off, that's maybe should be where the end, that period, that might be where that should stop. Claimant has served, okay, there's nothing, all right, there's no these, because there's no list of documents. So claimant, okay, put it this way. Claimant is serving these documents upon all appointed trustees to correct any error in any position any of them may have. No, to correct any error within the records, it's got to be a capital U, capital Y. See, because when you say capital U up here, you're referring to everything that came before this. So here and after you, yourself. So Iowa, Kim Reynolds, and the entire governor state of Iowa. So that's now you when you do it in capital. So you don't have to do that. So that's fixed. Claimant is serving these documents and all appointed trustees correct your error within the records, you and your office may have on file, comma, actually, hold on, may have on file regarding claimants. Okay, that works. All right. You and your office may have on file regarding claimant status and to correct any presumptions that would alter the same. Okay, now that makes sense. All right. Many of these presumptions strip we the people of our unalienable rights and have been used by foreign agents to replace those rights with privileges, civil rights, granted from corporations masquerading as de jure republic governments. True. All right. Nothing wrong with that sentence. A total list of these presumptions would be too long to include herein. However, the main three that are used against we the people are that of infancy. Okay. Are that of, whenever you start a list like that, you should do a colon or semicolon. I think semicolon would probably make more sense here. Okay. That of infancy, willful abandonment of our own estates. All right. Infancy, willful abandonment of our own estates, and death. Well, yeah. Well, I don't know if that's I would say the main three. Yeah. Infancy, abandonment, and death. Yeah, I guess that is the same three. I was going to say registration. Okay, so technically you say, all right, you could say main four and then say that we have willfully registered our property with the corporate state would probably be a good one. Okay, so, okay, and death being labeled as a decedent in the IRS master file known as the nubitant. True. These presumptions occur when our mothers abandon us as newborn children at foundling hospitals by, okay, that should be a comma there, by signing birth certificate contracts, again, comma, which in turn are registered under Roman civil law, thereby unknowingly making us all wards of the state. True, but that should be the end of that sentence, which then gives the state a presumption to administer our states until a claim is made by we the people. Yeah, okay, so that's right. That's the run-on sentence. Okay, so then we got to change this. All right, all wards of the state. All right, so say this in turn allows the state by presumption to administer our states until a claim is made by, okay, claim is made, comma, by we the people, comma, upon our own estates. Yeah, okay, until a claim is made by we the people upon our own estates. Okay, I guess that's fine. After 7 years of no, I almost feel like this should be another paragraph. No, okay, nope. I guess it's still explaining why. All right, after 7 years of no one coming forward to claim what was abandoned by documentation, the state then operates on the presumption that we are dead. True. This is proven by getting a copy of one's IRS master file in which we are all labeled as a decedent. A decedent is not dead, but pending death. Okay, a decedent is not, let's fix this. A decedent is not one who is dead, but one who is pending death. Another proof in regards to this fact is that all administration is upon our states. Wait, hold on. Another proof in regards to the fact that all administration is upon our estates. No, that's not right. Since it's the last part of the paragraph, I'm going to say furthermore. So, furthermore, proof of administration. Proof of, let's say this. Furthermore, proof of unwanted administration upon our estates is the fact that all W-9 and 1040 IRS forms are Class 5. Class 5 pertains to estate and gift taxes, not income tax. Okay, now that makes sense. Because claimant has learned about the abandonment of the people's estates by fraud, claimant had to also learn how to claim claimant's estate back, even if no one else in this nation ever does so. That's true. And it's funny that they're speaking that directly from me, but all right. It does go for anybody else that actually does get their VSOF status docs done and file them. Technically, that's correct for everyone, even though that's literally the reason I did it. But anyway. All right. The practice of having one's, okay, wait, is this could this be fixed? All right. Because claimant has learned about the abandonment of the people's estates by fraud, claimant had to also learn how to claim claimant's estate back, even if no one else in this nation ever does so. I guess, okay, that's not an incorrect statement. It's just a little bit choppy, maybe. All right. So that's all right. Otters like it choppy. So the practice of having to claim one's estate was at one time well known in England. Okay, all right, we need some commas here. The practice of having to claim one's estate, comma, was at one time well known in England, comma, in the courts of ward and liveries. Okay, no, known in England. How about a period? This was done in the court of wards and liveries, wherein every infant was made to sue his guardian for his estate. True. This process was referred to as suing out one's livery and was sort of a rite of passage for young men to come of full age, as stated in the Magna Carta. True. Now, you may be wondering, okay, that's right. When you're doing a notice, you don't really want to talk like this because it's kind of weird because it's like you're breaking the fourth wall. Now, you may be wondering, all right, so this needs to get fixed. So, okay, so just say, if you want to state it as a question, then let's just say what? Or you could say it like that. Okay, so now what? Okay, now what does this have anything to do with our American jurisprudence at all? That should be the end of the question. again, this is odd to write like this. Like, I might come back and change this, but anyway. And then that should be a capital U because you're talking to who you're serving it to. You may or may not know this constitutional republic has been under siege by the British ever since they lost the Revolutionary War. Claimant will not get into all the ways in which our republic has been attacked by the British Accreditation Registry or Bar Association. But suffice it to say, okay, so that should be a comma there. But suffice it to say, they now think they own our entire nation. Right. It's always the attorney that allows this situation to happen, but the ones that actually think they own the entire nation and the people within it are actually the Luciferian banking Jews. That's who really think own everything. The attorneys are just their proxy as to how they get it done. So you included by a very evil okay, all right. They now think they own our entire nation. You included. Oh, you included. Well, then that should be the capital U included, right, Mr. Governor? You included. By a very evil and misleading form of probate fraud. Okay, let's see where this. All right, let's see where this. Yeah, something's off here. Claimant will not get into the ways in which our republic has been attacked by the British Christian Ministry. Suffice to say, they now think that they own our entire nation, you included. This is perpetuated. This is perpetuated by a very evil and misleading form of probate fraud. True. This plan was spoken of by the handler of President Woodrow Wilson, a man by the name of Edward Mandela House. I say handler because House was an agent of the central banking cartel who ran the Bank of England, and they needed to be able to control a president in a way that he would sign the unconstitutional Federal Reserve Act. Okay, so technically, none of that, even though it's slightly interesting and historically correct, none of that is really required knowledge of the governor, meaning he doesn't need to know that because he's going to read the quote anyway. So I'm just going to blow all that out. All right. Edward Mandela House had to say in a letter to Woodrow Wilson, President, 1933, 1921. Very soon, every America will be... Okay, so everybody knows what this quote is. You guys want to read it on your own volition, just pause the video and read it. I did a whole class on this, so I'm not going to reread this. I know this is correct because it got copied and pasted. So anyway, all right. So did all that. All right. The fact that we, the people, now live in a nation completely controlled by corporations, and in many instances, the people are forced to sign. Well, you're not forced to sign. Let's fix that. The fact that we, the people, now live in a nation completely controlled by corporations. Let's say this. Controlled by corporations acting as de jure governments. Let's say that. Controlled by corporations acting as acting as if they were de jure governments. And in many instances, the people are forced to sign contracts or pay fine that supersede their state constitutions and unalienable rights, which bind the people to perform for these corporations. And that's all right. That is not only not quite correct, it needs to be fixed. The fact that we, the people, now live in a nation that has been taken over by fraud. I should list a few more things here. Taken over by fraud, coercion, which I never spelled correctly. Fraud, coercion, and lies. Let's say perpetuated by corporations. Perpetuated by. Yeah. Perpetuated by corporations acting as if they were de jure governments. All right, let's see if that fixes. The fact that we, the people, now live in a nation that has been taken over by fraud, coercion, and lies, perpetuated by corporations acting as if they were de jure governments. And in many instances, the people are forced to sign contracts or pay a fine that supersedes their... Okay, that's not correct. Because no one forces you into contract. That's not right. So what can we say here that actually makes some sense? Spectre, I think it Yeah, I think it is Blue Star's template, come to think of it. But honestly, I think this went through Blue Star, me, back to a few people, then back to me again. Then I started to give it out to people because I think it might have been the same one that I gave to you. But it, again, as I told you, it needed fixing. And clearly this part definitely does. All right, so I still got to figure this out. All right, so what are we saying here? We're trying to say that the corporations are worth fuck all and you're part of it. So stop stepping on me, basically. So the fact that we, the people, now live in a nation that have taken over fraud, criminalized corporation, acquisition, government's masons is okay. This is the problem. And in many instances, the people are forced to sign contracts. Not true. So how do we fix this? So let's say, yes, it is definitely deception regarding the contract process. So I'm trying to reword it in a way that basically denotes that says, hey, idiots, you're setting, okay, well, okay, in a sense, if they're forcing you, okay, I guess they do force you, because if they present a contract to you and then they say on the top of the contract, if you do not sign this, you will be fined $1,000. Okay, that is force. So that part of it is true, which I know the BC contracts say. I don't know if it says that on top of a driver's license contract or not. Probably not. Or at least I don't think so. Okay, so anyway. Corporations act in government in many instances. Okay. And in many instances, all right, how can we fix this? Let's do this. And these, come on now. These stated corporations present the people with contracts which they say they will be forced to pay a fine or fee if not entered into, comma, which is the same as a forced contract under duress. Okay, now, because again, these contracts do not, all right, back up. Okay, all right, now I think that makes sense. These, okay, then you see these contracts supersede, not there, but these contracts supersede the state constitutions and unalienable rights which bind people to perform for these corporations. Okay, that's true, but is that even needed to be stated? These contracts, yeah, I guess it's just a simple statement. These contracts supersede the state constitutions and unalienable rights which bind people to perform for these corporations. Let's say this. Perform under these contracts for these corporations. This process is no accident and has been the plan of men like Edward Mandell House for over 200 years. Okay. Who cares? Do we really need to state that? Don't think so. Claimant, having taken the time to learn the history of law and banking of America and England, is now well aware of the contractual nature of licenses, permits, and submissions of applications to these corporations, which is why claimant has rescinded 4 calls without dishonor, all of them that have ever been signed for lack of full, we need commas in here, signed for lack of full disclosure, comma, and under fraud by deception. I can you're right. This is definitely Blue Star's template because I can definitely tell when he's too wordy. Whenever I get something from him, he wants to talk as if the guy's like next to him in the room. And that's not the tone that you want to take in a notice. In the tone, particularly to the governor, the tone you want to take in a notice to a governor is like things like, These are the facts. This is what I know you're doing. And then at the end say, if you can prove me wrong, well, then, hey, tell me, right? But you don't want to get into this kind of, oh, I'm like talking to my buddy over the couch, because you're talking to the governor, right? So I think we need to, exactly, Flood. That's exactly what it is. He's always too verbose. He always puts too much shit in. He wants to throw everything in the kitchen sink into it, which is usually the problem. So in the end, if you have a tendency to do that, well, as Bill Thornton said, what you need to do is revision, 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 revision. And what you're trying to do in regards to writing anything regarding a notice or anything at law or a lawsuit, whatever it may be. If it's an official thing, the first thing you want to do is brevity. You want it to be as short as you can possibly make it. So, all right. In that feeling of what we're doing here, I think we should probably blow some of this out. So, all right. These contracts supersede state constitution. Okay. Period. This process is no accident. Okay. Okay. Okay, I'm just going to blow this entire thing out all the way back to here. Just goodbye, gone. All right, so then further proof of the deception, notice, so on and so forth. Now, does it really make any difference, or is it a really good idea to ever put links of something in a written document? No, not really. Are they ever going to go type this in? No. So even though I don't necessarily know what this is, let's have fun and go see what Blue Star was up to with this. I really don't know, truth be told. All right, let's punch this in and see if it's even if it's still a valid link to something. All right. House Bill, New Hampshire. Oh, okay. This was this bill that New Hampshire proposed. I don't know if this thing ever got passed. This was the right to travel bill, I believe. Yeah. It was the proposed right to travel bill in New Hampshire. Spectre, I don't know if this thing ever passed or not. But anyway, so in this, it was fairly interesting. So he kind of gets the point in here that, so I think it's in here that you get bound to have to obey the traffic laws because of contractual agreements, I think is the only reason why I brought this up. But anyway, a governor's not going to, or even the governor's office, is not going to go find a link, punch this in, and then try and figure out what the hell it is you were trying to convey in the addition of this in your paperwork. So pointless. So we're just going to blow that out too. All right. Claimant's noble goal of creating and filing and serving all these documents, correcting the public record, correcting the probate record, and putting safeguards in place, like the offer of contract now served upon you. See, that's again too verbose. Stop it. Claimant's noble goal of creating, filing, and serving all these documents upon capital U, meaning governor, is to correct your, because remember, capital U, your, is the governor's office, is to correct your records. Your records to correct, I'm going to say to correct any and all probate records, because here's the problem. You might have a probate record in your birth state, but then you get a traffic ticket in Tennessee, and then they run the traffic ticket through probate. Okay. Well, then it needs to be any and all probate records. And to put, because we're stating this all in present tense here, and to put safeguards in place, period. Okay. All right. Offered contract now served. Okay. 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 All of this is literally stated within the doc set. So he did not have to put all this in here. This is part and parcel of what is in the doc set. So there was no reason for him to have to repeat it. All right. Claimant's noble goal of creating, filing, all serving all documents upon you is to correct your records, to correct any and all probate records, and to put safeguards in place for any unwanted or unlawful administration of claimant's estate, claimant's entire gross estate. Okay, there we go. That makes sense. Now I can probably blow out the rest of this paragraph. Okay, like the offer of contract served upon you. All right, it's in the thing. And is so that claimant may protect all that claimant owns in law, settle claimant's entire gross estate in a formal probate proceeding, exercise claimant's right of blood and kinship, which cannot be destroyed by any Roman civil law. See, these are all things that are great and they're correct, but they're all in the status doc, so there's no reason for him to state it in the notice. All right, protect claimant's substantive rights and unalienable rights against all who would seek to diminish trespass upon them. Place any and all who would seek to administer claimant's estate under binding contract to perform as claimant has decreed regarding all matters of claimant's estate, and to live in peace and harmony with all of claimant's fellow people of Iowa. Okay, fine. Well, maybe that part could be left in. Okay, whack. All right. Chopped, comma, and to live happily ever after. Fine. If you have any questions about the contents of any of these documents, please feel free to write to claimant at the above stated address herein regarding said, and claimant will return promptly correspondence back to you as soon as possible. Okay, fine. The overall purpose of these documents is to demonstrate. See, he's like repeating himself again. See, this is again, that's what he does. He like states why he's doing it, which is he stated it up here. Right? So this is what this whole paragraph's about. Claimant is serving these documents because of these reasons. Okay. Then why are you restating your goals down here of why you have to, or what you're doing, right? It's, again, redundancy. Too verbose, brevity, knock it off. All right, so, All right, so you're in peace, fine. If you have any questions, okay, fine, as soon as possible, fine. All right, this is the point. The overall of these, okay, properly done, so the public record, the contract that governs your trustee appointment bearing record number, okay, so that doesn't need to be there. The served contract that governs your trustee appointment bearing public record number regarding claimant's estate, should you choose to accept it. See, again, he's talking about what's in the status docs. You don't need to say, should you choose to accept it by your binding actions, blah, 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 blah. That's already in there. He's going to have to read it anyway. Regarding claimant's estate, is one of the documents now served upon you. Okay, fine. Now, did we even need to say that? The served contract that governs your trustee appointment bearing public record number, there should be a comma here. Regarding claimant's estate, is one of the documents now served upon you. Okay, fine. I guess you want to make extra notice to the governor that that's where the trustee appointment is, fine. And give him the public record number of it, fine. Okay, that's no problem. Claimant is confident in knowing that you will take the time to carefully read and understand all of the documents now in your possession. That's irrelevant because at the bottom he should have said the same. Govern yourself accordingly. See, govern yourself accordingly says the same thing. So you don't need to say this. You don't have to be nice. Be like, claimant is confident that the governor will do what he's supposed to do. No, fuck you, do it. All right. After many long years, again, he's getting into it. I don't need to know your history. See, this is Blue Star. This is Blue Star telling his life's history again. Don't do this, people. Whatever you do, you don't need to do this in a notice. Again, this is facts, evidence, and the law. That's it. Okay, that's all you're dealing with. You're dealing with your grammar, your logic, and your rhetoric. Who, what, when, where, why, and how. And definitely leave most of the why out of it, and certainly leave most of the how out of it. Just who, what, where, when is pretty much all you need. Okay, so after many long years, this was the only route in action the claimant could think to take that does not lead the people and the United States government headlong into war. Okay, well, yeah, fine. Which of course is what the banking cartel would prefer to happen. Again, you can't get into what they might think or not think, and again, you're talking to the governor. Okay. Claimant, being a man of integrity, having honor and respect for all men and women created equal under God, now peacefully draws a known line, and then the imaginary line, so to speak, sees again, blah, blah, blah. All right. Probably can blow this whole entire thing out, but let me read the rest of this goofiness. None of what is spoken of in these documents created by claimant is meant to be seen. Okay, that's all you need to start right there. Okay, enough. That's where you need to start. None of what is spoken in these documents created by claimant is meant to be seen, is meant to be seen, or sorry, is meant as a threat, because you don't know how they're going to see it. Meant as a threat, and none of which claimant has created is to be seen as any form of intimidation or coercion. True. Because that's another thing. When you give notices, and people ask me this all the time, they're like, Zen, well, what happens when you do all this? Like, what happens when you serve people this? Oh my God, you're telling the governor to fuck off. Yes, you are. But you're doing it in a very nice, lawful way. You cannot threaten people, right? You can't send a notice saying, I'm going to sue you. That's a threat. How you send a notice is says, stop stepping on my feet or I will sue you. You have a duty not to step on my feet. Stop doing it. If you don't stop stepping on my feet, my only option here is to defend myself by filing a lawsuit. That's what you say. If you have to talk about lawsuits, if you have to talk about binding arbitration, you do it in a standpoint of defense, because you have the right to self-defense. Everybody does. And doing it by court case or doing it by lawsuit or doing it by binding arbitration is basically civil warfare. So you're not taking out your axe or your machete or your long sword or your samurai sword or your spear or your 50 cal and blowing somebody's head off. We're supposed to take care of these things peacefully. And will they obey when you do it correctly? Answer is yes. It's just that nobody's bothering to learn this. So, all right, these documents are to be seen as an absolute and unequivocal demand in law for what is rightfully secured by the state and federal constitutions. Well, okay, fine. The rights of blood and kinship and by natural and common law, which is every man and woman's. See, he just, right? You notice how he's, you notice how he tends to create run-on sentences? All right, let's see if we can knock all this out. None of this what is spoken is, all right, intimidating, all right. These documents are to be seen in absolute, which every man's woman's right. So one of the people of the state of Iowa and is American citizen, life, liberty, and pursuit of happiness, and to be left alone, which is, okay, this whole thing can be blown out. These documents are to be seen as an absolute unequivocal demand at law for what is stated within the documents. Now, these documents are to be seen as an absolute and unequivocal demand at law for what is stated within them. Done. That's all right. Them. Period. Finished. All right. Get out of here. All right. It is claimant's wish and will that all address. It is claimant's wish and will that you can't say all, because now who are you talking to? That you and your address claimant in claimant's proper name, John Henry, for all future correspondence regarding this and all of the matters. All right, fine. You may include the name of claimant's. You may include the name of claimant's house if you wish, but please refrain from addressing the estate name unless it is to the office of executor of same. Okay, now do you really need to get into any of that? Not really. You can pretty much just say it is claimant's wish and will that you and your address claimant in claimant's proper name, John Henry, for all future correspondence regarding this and all that matters, period. Claimant hopes these presents find you. It's got to be you and your. You and your. In good health and in happy spirits. Thank you for your time and attention to all that is stated herein, and your time and attention to all these documents now served upon you. Again, don't need to be that verbose. Thank you for your time and attention to, how do we finish this? These matters. Done. Govern yourself accordingly. That's always a good one. All right. Executor, John Henry, House Simon. That would be heir. state dignitary, paterfamilias. All of these are things you can put down if you want to. If you've done your doc set, you can say, and you're male, you can say that you're paterfamilias. If you're a woman, you can say that you're the materfamilias of your house. And you're one of the people of Iowa, definitely. And return address, so on and so forth, seal. And this is where you put your house seal that you've created. And if you guys don't have your house seal yet, well, then join the VSOF and we'll teach you how to do it. Because it's pretty easy and it's actually pretty fun to have one after they're done. Because then you can sign and seal all kinds of things. Because if you don't have a seal, you can't seal them. For the exception of your right thumbprint, because that's how the Japanese samurai have done it for thousands of years. But anyway, all right, so that's the governor one. That looks good, or at least highly improved. And I don't think I missed anything regarding red spots. Yes, you can use a signet ring. Some people have done that flood, which is also a really cool thing to have because then you always have it with you. And as did pretty much, I would say, probably pretty much every member of the peerage during, I would say, pretty much all of the Middle Ages. And even up to now, I've still seen men wander around with signet rings. So yeah. Yep. And okay, so that's that one. So what do we got next? Next one is up for grabs that's the governor. And this one is for Secretary of State. Hold on. Is this verbatim of what we just did? I think it is. So, okay, so that one we don't have to redo unless I have to put it next. Nope, this is the same thing. Okay, so this one would be fixed same as the other one is. All right, so I won't have to do that. Okay, so I don't have to do this. I'll just have to copy and paste what's in the other one into here and then fix it. Also, by the way, this is another way I can always tell it's always Blue Star's document. So, well, yeah, I could save it as version 2, I suppose. But if I don't save this one, then it'll automatically be saved as it anyway. Blue Star's got this thing about always having a lot of stuff underneath in the footer. You don't need all this stuff. Like some of the stuff is like his personal codes. So this doesn't need to be in here. All right. So cover letter for Secretary of State of Iowa and all future successors of the office. That's pretty much all you have to put in. So I can pretty much blow all the rest of this out. Page 1 of whatever. Okay. That's it. He likes to put things in like all rights exercised, blah, 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 blah. That doesn't really matter. Plus, it doesn't matter what's in a footer or a heading because headings and footers don't control the document, nor do like the court headings that you saw in the beginning when I put up the affidavit of service. Is it a better substitute for a thumbprint for the seal? Not necessarily. There's a document that we do at the VSOF, which is called Notice of Publication of House Seal. And so that's where you establish your house seal on the public record. Now, whatever you put into the little spot that we give you in that document for what your house seal is, then becomes your house seal forever regarding all matters of whatever you may be doing at any point in time for your house, your estate, and your court. Now, if you wanted to put your thumbprint, your right thumbprint in that position, you could do that. The problem is that any of your then heirs or assigns or posterity aren't going to have your thumbprint handy, right? And I don't think you want to be having them forced around carrying it in like a jar of formaldehyde for the rest of their life. So that's why you create a house seal. And in substitute to prove who you are, yes, you can put your thumbprint down. But your thumbprint is usually for those that have not yet established their house seal. Unless, again, you state it as you do in the seal notice or you're a Japanese samurai. Okay, so anyway, not going to do this one. Again, we'll just redo this as the other one is. I think this is a shorter version, and I think he decided to even get more verbose in the one that we just fixed, because I think this one is actually shorter. But anyway, all right, so that's what I'll do with that. They can keep my thumbprint after I'm gone. Well, if you put your thumbprint I suppose you could do this. If you really wanted it to be your thumbprint like forever, which I think is slightly egotistical when you establish your own house. I don't think that's being a very good paterfamilias. But anyway, if you wanted to, you could put your thumbprint in and then you could get a corporate seal, literally an embosser that would look the same as your thumbprint. So I guess you could technically do that. But I know that you're half joking anyway. See, this is what I do all day. So just so you guys know, this is the kind of stuff that I do. This is what I edit. These are what I create, is documents like this that go along with the VSOF status docs. And also, it took me a good 10 years to create the Vocational Science of Freedom status docs. And those status docs, some of which have been edited over 167 times. And yes, I keep track of it. So from that standpoint, I will now bow out from doing the rest of that. When these are done, they will all be available to everyone who has ever done their Vocational Science Freedom Status Doc set. I will make sure that I put them into the mega folder for the handbills for the VSOF so that anybody can see them at any point in time and download them at any time that they want to use them of their own volition. I always give templates to the people, and when I do give out templates, it is 100% your responsibility as to how you use them, okay? As is with the Vocational Science Freedom Status Doc set. And so, last public service announcement, if you would like to join the Vocational Science Freedom, please go to vocationalsciencefreedom.org and then click on the Welcome Package in the upper top bar, which will take you here, and then please download it. It is a fillable PDF. Please fill it out and then email it back to vsof@protonmail.com. That will then get you into the Vocational Science of Freedom Revolt server, and will also get you set up with the Vocational Science of Freedom classrooms, which we hold on Mega. You have to set up Mega first, and then I have to allow you into the classrooms. But it teaches you how to set up your free Mega account and how to get that done. And then all you have to do is just send me a friend request on Mega after you've done that, and then I will add you to the rooms. And if you're interested in doing your Vocational Science of Freedom status doc set, the information is also on the Welcome Package page. Just scroll down a little bit farther, and there's a whole handbill for it on how to begin and how to get going and how to do that, including how to make your house seal and how to get authenticated copies of your birth certificate back from the federales so that you can actually have a legitimate title to yourself. Okay. I didn't see anything else in chat as far as questions, unless Spectre, you had any. Okay. I don't see anything. Okay, cool. All right. Wait, actually, Wilby had something. Static said, where are these docs held? Do you mean the VSOF status documents themselves? Is that what you're talking about, Static? Because the Vocational Science Freedom status docs, after I finish them, I email them to you in a locked PDF. And then after they're emailed and I know that you have gotten them, I delete your personal information and your doc set off my computer. Oh, you're talking about the notices. No, I haven't put them up yet. You must have got here late. I thought I said in the beginning, I haven't created the mega file for tonight's class yet. Once I do, it probably won't be these documents anyway, because I still need to fix them, clearly. So I'll still have to be doing work on them. I just wanted you guys to see how I work on them. So when I get done with these notices, they will be in the mega file that contains all of the rest of the handbills for the Vocational Science of Freedom status doc set. The normal file that's in and is available on the Revolt server that has a mega link in every single show note for every single class on every single platform. That mega link, the one that everybody should easily have access to. So that's where it's at. Okay. So, all right. Actually, you guys both had the same question. All right, cool. Okay. So that's it for tonight. Thank everybody for showing up. Good to see you, Flood, and everybody else on Rumble, Not Nerdy, Harley, Honeypot, all you guys. Thanks for showing up. Thanks for supporting me. And good to see all you guys, obviously, on the VSOF mega server as well. We had a good turnout tonight. And hope you guys learned something. And if you need to, obviously go back and re-listen to this to see how I do this stuff. And then I will post the master files for these documents, as I stated. So with that, hope you guys had a good time. Hope you learned some. And I will see all of the VSOF members on Wednesday for our roundtable. And again, if you'd like to join, it's exactly how you do it. Just go to the welcome package, download it, and join up. And then you can join our Wednesday night open roundtables, which are completely open. Anything goes, talk about anything, bring up anything, talk about whatever you want. It's fine. Open session. And until that time, have a wonderful rest of your weekend. And as always, stay safe and stay sovereign.